All right, it looks like everybody's in. Hello and welcome to our panel, Ending the Endless War on Drugs. My name is Brandon Berg. I'm a 3L here at Maine Law and Secretary of the Multicultural Law Society. One of the Multicultural Law Society's objectives is to educate our classmates on issues impacting communities of color, as well as underrepresented ethnic and cultural groups. We hope that our panel today helps contribute towards that objective. Our topic today is the war on drugs, and we have joining us 5 panelists who, over the course of the next hour, will help us better understand what the war on drugs is and how it has affected our criminal justice system. Our panel will be in 3 parts. First, our panelists are going to help us identify what the war on drugs is and some of the problems it has caused. Second, our panelists are going to help us identify some of the possible solutions to those problems. And finally, if time permits, we will take live follow-up questions from our attendees. I should note that even though we're allocating time for attendees to present questions to our panelists, we encourage attendees to submit questions throughout the webinar using the Q&A feature in our software. That said, here are our panelists. First, we have Judge John D. Levy. Judge Levy brings with him a wealth of knowledge from both the state and federal systems. He has served as a Maine District Court judge and Justice of the Maine Supreme Judicial Court. His appointment since his appointment by President Barack Obama and confirmation by the Senate, Judge Levy has continued to serve as a judge for the United States District Court for the District of Maine. Judge Levy, we know you have a prior obligation and will have to leave partway through our panel, but nonetheless, thank you so much for being here.
Thank you.
Next, we have Professor Christopher Pulos. After graduating Maine law in 2016, Professor Pulos's professional pursuits were influenced by his experiences in the criminal justice system. Utilizing the skills and knowledge he attained at the Cumberland Legal Aid Clinic, Professor Pulos went on to serve in leadership roles for organizations that seek to help those suffering from addiction and reform existing drug laws in the United States. Currently, he serves as an adjunct professor at Seattle University School of Law, teaching drug law and policy, and is executive director of the Washington State Reentry Council. Professor Pulos, thank you for being here.
Thank you, Brandon. Happy to be here.
Third, we have Professor Jemesa Drake. In addition to being a member of Maine Law's adjunct faculty, Professor Drake has spent her career focused on appellate litigation. Having worked for the ACLU as a public defender and now in private practice, she has appeared before the highest courts in Maine, Oregon, and Kentucky. Notably, in 2011, she argued the precedent-setting case of Kentucky versus King before the US Supreme Court. Professor Drake, thank you for being here.
Having me.
Fourth, we have Professor John Chapman. As a lifelong prosecutor and former chief of the criminal division of the U.S. Attorney's Office, Professor Chapman has prosecuted and advised on numerous drug cases during his career. And as a Maine Law adjunct professor, he teaches evidence, trial practice, criminal procedure, and white-collar crime, to name a few. Professor Chapman, thank you for being here.
Thanks for having me, Brandon.
Finally, joining us from South Florida, we have Mr. Oscar Arellave. Mr. Arellave began his criminal defense career in the 1980s as the Medellin cartel was making its rise to prominence. Based in Miami, he has represented a diverse population of individuals from Central and South America, including high-ranking members of Pablo Escobar's Medellin cartel. Most recently, he helped secure the extradition of Escobar's second-in-command, Carlos Leder. Mr. Arellave, thank you for being here.
Thanks for the invite.
With that said, I think we can go ahead and get started. So Professor Pulos, I think we'll direct the first question to you. What is the war on drugs? What problems has it caused? And why is it important that we discuss it?
Sure. Thanks again, and it really is an honor to be here. I wish I could be there in person. This is the first year in my life, besides the time when I was actually incarcerated in federal prison. Other than that, this is the first year that I'm not making it home to Maine. Let me just switch the view here. There we go. I was just seeing myself very huge, and I didn't really necessarily want to have that view. So every year, actually, since I've come home from being incarcerated, I've made it back to Maine and climbed Mount Katahdin. So I'm kind of bummed that I'm not able to be there in person and do that this year, but I'm erring on the side of caution and not doing that trip this year anyhow. I'm happy to be here virtually, at least. So the war on drugs is, the term itself was launched, I believe, by the Nixon administration and then kind of amplified by the Reagan administration. And then it continues right through today. But I often, now I'm a student of history of drug policy, and that's what's really changed my views around drug policy and around the drug war. And so while the motto of the war on drugs came about under President Nixon, the actual drug war itself and drug prohibition came much earlier and really began in the late 1800s, early 1900s, included alcohol, as we know, for a while. That was ineffective. And it continues to this day. Why is it harmful, I believe you asked? And I believe it's harmful because it's a supply side approach to drug policy has just proven over and over again to be ineffective. We have been unable to stem the flow of drugs, and I've also found historically that it's somewhat arbitrary as well. For example, when I was 15 years old, I was arrested, put in handcuffs, and brought to the Cumberland County Jail for cannabis. And now when I drive down I-5 in Washington State, I see huge billboards for cannabis. And it makes me shake my head that, as the generations change, various substances fall in and out of favor, depending on culture, depending on who's in power, and actually even depending on political viewpoints and different groups that may be targeted for various reasons related to drug policy and other views, etc. So that's kind of the history in a really, really brief nutshell. The impact has been highly disparate against people of color, particularly Black men in particular. And enforcement, of course, is not conducted in the same way across all communities and across racial and economic lines. An example I like to use for people that may not be from Maine is in New York City versus Greenwich, Connecticut. We could say Kennedy Park in Portland versus Cape Elizabeth on Shore Road. Police are just simply not doing aggressive, stop and frisk type drug enforcement in certain neighborhoods, and therefore lower income neighborhoods that have high proportions of people of color are being negatively impacted, although studies have across the board shown that people of various races and socioeconomic backgrounds actually use substances, including illegal substances, at similar rates. And something I wanted to note right in the beginning is sometimes my views are misperceived as being somehow pro-drug or pro-addiction. And I'm certainly not at all pro-drug or pro-addiction. I've experienced addiction myself. I've lost countless friends to addiction. And at some point in my education and studying the history, I just came to a realization that what we're currently doing is not effective in stopping overdose deaths. It's not effective in reducing the drug supply. And I think it's time that we look at the big picture and make some serious changes.
So to understand drug policy, we need to understand, obviously, a lot of the mechanisms that are in place. So this next question is for Judge Levy. Judge Levy, one thing we've seen is a lot of, as a result of these policies, is mass incarceration. But to understand those, we need to understand the U.S. Sentencing Commission guidelines. What are those guidelines? How do they relate to mandatory minimums, and how do they affect a defendant's case and a judge's ability to sentence individuals?
Thank you, Brendan. As you mentioned when you introduced me, I spent most of my judicial career as a state judge in the Maine state court system. And I want to begin there because it provides sort of a contrast to what I'll then describe as the federal system. In the state system, which I guess you could say does not have a war on drugs, sentencing is really a very highly discretionary process with the sentencing judge. It's a three-part analysis. The court looks at the crime itself and tries to figure out how serious the crime was relative to how that crime could be committed. It looks at various aggravating and mitigating factors, primarily focused upon the offender, him or herself, and then makes a decision on whether part of the sentence should be suspended. In other words, the sentence will be 10 years, but the defendant only needs to serve 5 years. Again, usually based upon mitigating factors associated with the offender himself. So that's, I think, fairly characterized as a highly discretionary system in which a lot of trust is put in the hands of the judge. In contrast to that is the Sentencing Commission guidelines. I happen to have brought my manual with me, which is this book, and you can see that it's several inches thick. The Commission guidelines are the product of the U.S. Sentencing Commission, which was created in 1984 by an act of Congress, the Sentencing Reform Act, which I guess one would say is part of the war on drugs, what's been referred to as the war on drugs. And the purpose of the guidelines was essentially to require that every federal judge in every federal district across the entire United States applies exactly the same criteria in sentencing defendants, that there would be predictability and not variations that were not based upon some type of local considerations. When they were first adopted, the sentencing guidelines were mandatory. That meant that the judge was required to go through the calculation, hear the arguments, and within the narrow bands of discretion afforded by the guidelines, sentence the defendant. In 2005, I believe it was, beginning in the Booker case, the U.S. Supreme Court issued a series of decisions which, for various reasons, concluded that the guidelines could not constitutionally be mandatory, but that they are advisory. And so the guidelines are still in effect, and they are still a centerpiece of sentencing today. But in the end, the judge has the discretion to vary from the guidelines. In the state court system, sentencing is largely a function of case law and custom. And when custom or culture, and when I say that, I mean what the prosecutorial bar, the defense bar, the judges, and the community generally understand to be the fair range of sentences for a particular offense, given circumstances. In the federal court system, I think it's fair to say that the guidelines themselves provide culture. They really are the driving force as to how we go about the sentencing analysis. So I'd like to give you just a few examples as to how they operate and how they affect drug sentences. If you have a defendant who pleads guilty to conspiracy to possess with the intent to distribute cocaine base and more than 100 grams of heroin, under the US Code, that's a charge that carries with it a mandatory minimum sentence of 5 years. Right, so that's a function of federal statute. And then for that defendant, that is the required result by virtue of the indictment. So it's the charging decision by the prosecutor, not the sentencing decision by the judge, which results in the fact that the sentence will be not less than 5 years. So again, you can see that in a situation like that, with a mandatory minimum, the required 5 years doesn't pertain to the circumstances of the offense or any mitigating or aggravating factors regarding that defendant, simply a function of federal law. It doesn't matter whether the defendant might have been the ringleader or whether the defendant might have been a lower level participant. Again, the minimum mandatory sentence is 5 years. Also, the guidelines are very focused in terms of drug sentencing on the quantity of drugs that are provable as to that defendant. And so I gave you the example of a defendant charged with 100 grams of heroin, a minimum of 5 years. Take the same exact facts and the same defendant, but a smaller amount of drugs, let's say 80 grams, and you have a very disparate result because there the 5 year mandatory minimum doesn't apply. The court has much more discretion, and you might find a sentence in the range of 2 to 3 years by way of a general example. The guidelines do, however, create what's called a safety valve for mandatory minimum sentences imposed by federal law. And that means that if the safety valve applies, the mandatory minimum sentence does not apply. And that generally comes into play if the government moves the court to find that the defendant has provided substantial cooperation to the government. And if other criteria are met, the court, if it makes those findings, is no longer bound to the mandatory minimum sentence. So what does that mean in terms of sentencing generally in drug cases? First of all, as I've already pointed out, mandatory minimum sentences in federal statutes leave the decision for whether that minimum mandatory sentence will be applied to the United States attorney, not to the judge. That's not a decision that is subject to judicial review. Secondly, the guidelines provide strong incentives for defendants to cooperate and provide assistance to law enforcement because of the safety valve, as I just described it. But that does point out to the potential for some unfairness, because a defendant who does not have much to offer by way of information is at a disadvantage to a defendant who does have much more to offer. So you can imagine a situation where a lower level participant in a conspiracy is less likely to qualify for the safety valve than a higher level participant in a conspiracy. And so overall then, you can see how the guidelines and minimum mandatory sentences limit judicial discretion. Now, I want to talk about one other aspect of the guidelines that are important when it comes to drug offenses, and that's called the career offender designation. The guidelines provide that if a defendant has 2 prior felony convictions involving controlled substances, then they can be deemed a career offender for purposes of sentencing. And that has the effect of enhancing the sentencing range from what it might otherwise be for that defendant to the highest level possible. The highest level possible is category 6. And so by way of example, if you assume an offense level of 30 and a criminal history category of 2, that would be a sentence of no less than 97 months under the guidelines. However, if that defendant qualifies as a career offender, the sentencing range, the minimum of the sentencing range increases to 168 months. So perhaps about a 75% increase in the sentence based upon those prior convictions. And that's without regard to the nature or the substance or the seriousness of those prior convictions. So a prior conviction for a prior conspiracy obviously will contribute, but so might a prior conviction for low-level drug dealing, sort of retail drug dealing on the street. So those are the ways that the guidelines operate to reflect congressional policy to impose very harsh sentences on defendants who are convicted of drug offenses. Having said all of that, I want to emphasize that I'd say the majority of cases that I see in federal court do not involve mandatory minimum sentences, and they do not involve career offenders. And so my discretion in those cases is quite broad. To its credit, I think the federal judiciary does a very good system, a very good job rather, with respect to understanding the unique circumstances of each defendant. Each defendant is subject to a very thorough pre-sentence evaluation, and factors such as physical health, addiction, the defendant's opportunity to rehabilitate, and so on, are really the focus of most sentencing to take place in federal court. Nonetheless, the aspects of the guidelines that I discussed do result and can result in some very harsh sentences.
Well, thank you for that explanation, Judge. And Professor Drake, you know, in your appellate career, you've argued a lot of constitutional issues. Given what the judge just told us, what constitutional protections have possibly been eroded in pursuit of the drug war?
Well, I'll begin, I guess, by drawing the kind of distinction that could really only be tolerated in a forum like this, which is to say that I don't think that there's this thing as sort of absolute and abstract constitutional guarantees that exist separate from what the United States Supreme Court declares them to be. In other words, the constitutional protections are what the court says that they are. But we can talk about the erosion of privacy that's occurred in the past few decades. So I think it helps to sort of think about how we move about the world, how we interact with our communities. And if we're going to generalize, we can say we do that by driving and walking. So we start with driving. Under existing case law, the police can pull over any motorist who they suspect of committing a traffic violation. But our traffic code is behemoth. And it includes many provisions that allow for the subjective observations of a police officer to play a large role. So for example, was a motorist operating in a safe manner? Because of the way in which we've enacted our traffic code, many people believe that it's essentially impossible to drive for any length of time without committing a traffic infraction. But there's more. In addition to being able to stop someone for committing a traffic violation, that stop will be upheld even if the police are later found out to be wrong about the factual or legal basis for the stop. So for example, if the police pull over someone for having a busted taillight, but it's later discovered that in fact there was no problem with the taillight at all, that stop will still be upheld. If a police officer pulls someone over for a busted taillight because they think under the traffic code having a busted taillight is a violation of the traffic code, but it actually isn't, that stop will still be upheld. And under existing case law, once the stop occurs, the intensity of the interaction between the police and the citizen can escalate quite severely. The police officer can order the motorist or any passengers to step out of the vehicle, and they can conduct a pat frisk, a limited search of the motorist or of the occupants. And then, if during the course of that, the police officer decides that he or she has suspicion that there's something else besides maybe just a traffic infraction going on, they can extend the temporal duration of that encounter. And this is our jumping off point for talking about encounters between police officers and citizens on the street. If you're just walking down the street, you can be stopped by a police officer if they have reasonable suspicion that criminal activity is afoot, that a particular person is engaged in criminal wrongdoing. And so I want to make 2 points about that. The first is these kind of stops, whether it be a stop on the street or a stop of a motorist, are they're occurring with much greater frequency than I think maybe courts and the public realize. So for example, litigation in New York City uncovered the fact that from 2004 to 2014, the New York City Police Department had conducted over 4.4 million stops of people on the street. And over 80% of the people who were stopped were either Black or Latino. And here's the thing, they were stopping based on these notions of criminal activity being afoot, even though the likelihood of stopping a Black New Yorker and whether that would yield a weapon was half that of the stop of a white person. The likelihood that the stop of a Black person would yield contraband was 1/3 of the likelihood that contraband would be discovered were a white person to be stopped. And so this sort of leads to my second point, which is this notion that these stops can be supported by suspicion just so long as a police officer can identify, can articulate something that is suspicious, has really, in my view, spiraled out of control. So a police officer might say, I believed that criminal activity was afoot because, among other things, the suspect appeared nervous. And then a court might say, well what was the fact that gave rise to the inference of nervousness? And here we have case law that covers the gamut. Police officers saying, believed they were nervous because they wouldn't make eye contact with me, or I believe the suspect was nervous because they looked at me too intently. I believe the suspect was nervous because they were jittery, or they were nervous because they were too calm. And so in my view, for much too long, courts have uncritically accepted these police officer articulations of suspicion, including when police officers are saying that citizens are engaged in innocent behavior, but it's nonetheless somehow suspicious. And this has been used to justify these really severe intrusions on the daily life of predominantly people of color. Now, I haven't mentioned really maybe another way that we interact with our communities, and that's digitally. And now we are on sort of the new forefront of Fourth Amendment jurisprudence, and it will be up to all of you as recent law, soon to be law graduates and practicing lawyers, to help us understand sort of the guideposts for privacy protections in the digital world. It's a very exciting time to begin practicing a criminal law and criminal procedure.
Thank you, Professor Drake. So briefly to Mr. Ariave and Professor Chapman, one of the other, considering some of these constitutional protection issues and the US sentencing guidelines, how has the war on drugs affected jury trials and whether or not an individual goes to, decides to go to trial?
Sure. Professor, I'll defer to you first.
Well, yeah, I probably should point out first that I am no longer a federal prosecutor. I retired a year and 2 months ago, so I'm no longer associated with the U.S. Attorney's Office. I want to make sure everybody was aware of that, and I'm certainly not speaking for the Justice Department. You know, I noticed, Brandon, one of the sub-questions you asked as part of that in the materials you sent out was, why do innocent people plead guilty? And I think that is a fantastic issue and needs attention. And maybe I can just jump to that. My view of that is because some prosecutors' policies and charging practices create leverage and too much leverage. And I'm referring to, and I'm not referring now to federal prosecution procedures, not that they're perfect and not that they're not subject to criticism. The ones I'm referring to are those in which a prosecutor will charge a weak, very serious offense with the intention of forcing a guilty plea to a lesser offense. And that creates a situation to my way of thinking, inappropriate leverage and causing people to plead guilty to charges maybe not that they're totally innocent of, or maybe that they are totally innocent of, but in any event to charges that perhaps are weak and could have would otherwise have warranted a jury trial. The Justice Department's policy on charging is that, and a lot of people are familiar with the standard of charging the most serious readily provable offense. Well, that's one of the most misunderstood standards, and I'm not going to get into detail of that about that, other than to say that that's only half the picture. The other half of the picture is that if you charge it, then you're stuck with it. And that is a policy against overcharging. That is a policy that discourages line prosecutors from overcharging with the intent to get a guilty plea to something less, because that's a damaging situation. Now, that is not to say that there's never a situation in which a major count is dismissed because somebody is pleading and somebody is pleading to a lesser count. What I am saying is that I think responsible charging policy is that when that happens, it has to be justified. It has to be justified in a written merits-based argument that a line attorney makes and has to be approved at higher levels. So if a minimum mandatory is charged and there's a proposal that a person plead guilty to a charge that does not contain it, that should require a demonstration as to why that is appropriate under the facts and the law. That's my take on the horrible idea of somebody pleading guilty to something that they didn't do. I think that makes everybody cringe. My experience in federal court in Portland is that that doesn't happen because we have a highly competent defense bar, we have an ethical prosecution bar, and we have a bench that, quite frankly, I don't think would stand for that. Has it never happened that somebody pled to a charge that was weak? Yes, but I don't think when that happens, I think it happens because of a failure of good charging policy rather than the absence of any charging policy. And I'll also say that the Justice Department approach on that is in many districts in the country more honored in the breach. So that kind of thing does happen in any number of districts, oftentimes, frankly, in large districts, which operate much more autonomously. But anyway, I identify that as a significant issue, with respect to the question you asked, Brendan.
Thank you, Professor Chapman. And Mr. Arayave, we'll get your thoughts in just a moment. Judge Levy, I know you do have to depart, but before you do, we have one last question. We have a lot of future leaders for the state of Maine and beyond. If you had to direct their attention to one particular issue related to the war on drugs, what would it be, why, and what would you have them do about it?
Well, I think we've already touched upon a few of the keys, and so I'll simply tick off to re-examine the social value and the effectiveness of mandatory minimum sentences. Certainly, that's something that deserves attention and consideration. We've seen Congress begin to do that with the adoption of the First Step Act in 2018. I won't get into that in any detail, but that is really an important shift in congressional approaches to this area. So that's interesting and something to be considered. And thinking about disparate outcomes and reform, it's really outside my expertise. But I will tell you anecdotally, as a judge who has had, I've had the responsibility of sentencing many people now. You can't help but see how many folks that come into federal court ultimately on serious drug charges came from such disadvantaged backgrounds. I mean, these are people whose childhoods are marked by drug use. Parents might have been drug users, whose childhoods are heartbreaking. That's a regular theme of the people that we see in court who are engaged in serious drug crimes. And so it seems to me that the bar not only has to be concerned with legislation, not only has to be concerned with adjudication, it also has to be concerned with social policy and the types of things that help people get ahead in life in a way that doesn't result in that type of a path leading a young man or woman into federal court to be sentenced for a drug conspiracy. That affects matters such as nutrition, education, early childhood education, all those things which I think everyone is familiar with, which we all know as a society are important cornerstones to giving people a fair chance to make it. It really does seem to me that as lawyers and as judges, we can't turn a blind eye to that as certainly being a source of the type of disparate outcomes that have been seen at times. I regret that I do have to leave for now for another commitment. I do want to thank Brandon, you and the organization for inviting me and the other panelists. And with that, I'll bid adieu and say thank you.
Thank you very much, Judge Levy.
Okay.
So, Mr. Arayave, returning to jury trials, what has your experience been with jury trials, and why do some clients, innocent people, plead guilty in your experience as a defense attorney?
Well, first, let me say that I think it's unfortunate that the term that was used was the war on drugs, because war implies brute force, and I'm not sure that this is a problem that can be resolved with brute force. In fact, I don't think this is a problem that we can get ourselves out of by incarcerating so many people. The guidelines, they have a coercive effect on defendants. In the Southern District of Florida, something like 93% of all cases are resolved by pleas. And the reason for it is, one, because of the minimum mandatory penalties. Also because of some of the aspects of the guidelines, for example, acceptance of responsibility, which is rewarding you if you accept your guilt and not go to trial. But you could look at it the other way around and say it's punishing you for going to trial. It's like a built-in trial tax. The other thing is the enhancement for obstruction of justice. If your client, if you think that it's important that your client testify in the case, the obstruction of justice enhancement comes in, and your client could be 100% truthful, and he could be hit with obstruction of justice because the jury found him to be guilty, and that implies that they rejected his testimony. The other thing is one of the reasons why so many people plead out rather than go to trial is because there's limited discovery in federal court generally. In Florida, in state court, we have something that I don't think too many jurisdictions around the country have. We're able to take depositions of the police officers and of all the witnesses, including the informant. And there's a certain cost built into that, but I think in the long run it saves money because the defense is able to evaluate its case rather quickly and determine whether in fact the plea is the route to go, and the client can see it also, and he can base his decision based on the merits of the case and not on the coercive effect of the guidelines. Regarding the drug guidelines, there was a former judge from New York. His name is Judge John Gleason, and he was a former federal prosecutor. He was a federal judge for a long time in Brooklyn, one of my favorite judges. And he wrote an opinion in a case called United States versus Diaz. Anybody that's interested in the guidelines and the defects in the guidelines should get a copy of this and read it. It's the case number is 11-CR-00821-2 parentheses JG. It's from the Eastern District of New York, and he states basically that the guidelines were born defective because of the minimum mandatory guidelines, the minimum mandatory sentences, rather. The minimum mandatory sentences were supposed to be for the larger players in the game, for the organizers and supervisors and for the mid-range people. Then when the Anti-Drug Abuse Act was enacted, because the guidelines, the way they were structured, left cliffs from the minimum mandatory sentences, the commission adjusted the guidelines to conform with the minimum mandatory sentence. So what the minimum mandatory, and we have guidelines now that are based on drug quantity, which is not necessarily a good proxy for culpability. And according to Judge Gleason, the guidelines are the main reason for over-incarceration, for the incarceration problem that we have in the United States. We have so many people that just plead out to get it over with and not have to face the consequences of this. I think that we're going to have to do something in the legal system to compensate for this vanishing jury trials. I think we're going to have to build in more procedural safeguards in the plea procedure. Perhaps wide open discovery, open file discovery from the government, and even perhaps depositions, so that the pleas can be better informed. And if anybody ever wants to go back and look and see, whether there was a factual basis, whether the person was coerced, they could look at the depots and it would be very clear. Right now, it seems to me that the urgency is to move the pleas along as fast as possible. And if you say that you want to go to trial, you get looked at like you're from outer space. It's a real shame that the trial, we don't have more trials now, because somebody needs to be policing the police. Somebody needs to be cross-examining police officers, whether it be in depositions or in motion hearings or at trial, but there's not enough of that. And we're getting into situations where whatever the police says is the law, and we have to live with it. We can't dispute it. If you dispute it, you're not going to get acceptance of responsibility. You know, it's a catch-22 situation.
So I think that's a good segue into our next section, sort of what to do going forward. I think we've identified a lot of the areas of the problem areas of the war on drugs, and I guess I'll open it up to all panelists. What are some of the solutions? You know, is the appellate process effective? I see one attendee had asked about the effectiveness of drug courts. What are some of the solutions that we can implement? And this is for, again, all panelists.
All right, I'll take it. I think that, again, Judge Gleason talks about a young drug user that he was sentencing. And he felt bad because he felt that this case was threatening the defendant's claim to a future because he was getting hit with a 5-year min-man sentence for a minor drug case. A drug case that perhaps could have been taken care of through a diversion program, pretrial intervention, some sort of drug treatment program. And, you know, going back to the term war on drugs, this should not be a militarized effort. This should be recognizing that drug addiction is a medical problem that should be treated by medical professionals and should be, and the solution to it should also involve education, educating the people that are prone to use drugs. And if we're able to do that, and we can have more resources available for these diversion programs and drug courts and that sort of thing. I was reading in one of the materials that I had that the Bureau of Prisons budget is equal, the Federal Bureau of Prisons budget is equal to the budget of the entire judiciary. That's a pretty scary thing. And now, as they're having to take more money for the Bureau of Prisons, then that takes away money for things like the courses of the First Step Act that were recently enacted. That great law, but the courses that you need to take in order to get credits for benefits under that law are not available because there's no money. And there's no money for diversion program, all kinds of things, because it has to be put into the Bureau of Prisons. So we're feeding this monster that's preventing us from doing more creative things that would tend to mitigate the incarceration problem that we have. The final thing I want to say on that is we have the Sentencing Guideline Commission. They're aware that we have an over-incarceration problem. And so we have some nominees for the Sentencing Guideline Commission. Some names have recently been put out, and I'm not going to mention the names, but one of them goes by the nickname of Hang 'em High Henry. And he is quoted as saying, "I live to put people in jail." And the other one is somebody who gave a nonviolent first-time offender 162 years in prison. And it was, I don't know how nominating people like that are going to resolve the incarceration problem we have. Thank you.
Professor Pulos. Sorry, go ahead.
No, that's all right. I don't want to interrupt.
No, please, Professor Chapman, go ahead.
You know, this is not maybe a real concrete answer to your question, Brandon, but I think it's a way of looking at it. Chris mentioned earlier that there's the war on drugs was not the only experience with prohibition. And I agree with that analysis. I think if you look at the history of America's relationship with substances, you see, 50 or 60-year cycles. Going back to the colonial era, when alcohol was king, right? A lot of drinking going on back then led to the first prohibition in the early 1800s, which lasted a while, and half the states were dry and half weren't. That morphed into a period of substance use in the mid to late 1800s. Coca-Cola had cocaine in it. Heroin was sold over the counter. That leads in the early 1900s to the prohibition that we're most familiar with, which was government's response to that. Post-World War II, we see an increase in alcohol use, drug use, all the way through the 60s, 70s, and the war on drugs becomes another form of prohibition. Those didn't work. The prohibition didn't work. There were serious problems with prohibition. There are serious problems with the war on drugs as it was waged in the latter period. So I say the other lesson is, you know, that the problem of substance use and abuse is not solved, and it's gonna come back. I think the key is to strike with reforms. Strike while the iron is hot. Strike while violent crime rates are still relatively low. They came down starting in 1992 to a much lower level today, giving us space, giving us as a society space to implement some strategies. But now's the time, because the problem's not going to go away. Substance use problems are going to endure, and while the public is of a mindset that crime rates are low, is the time to do it.
Brandon, may I just pick up on that point?
Yes, of course.
If we accept what Professor Chapman is saying, that substance use disorder is something that unfortunately will be with us as a society, then it's up to us to decide how we will respond to that. And as your question asks, what sort of changes can be implemented to make sure that we have a more measured, reasoned, fair response in the law? And so I can offer three suggestions. The first is there's a tremendous opportunity for state courts here, and many of you will begin your careers practicing in state courts. State courts have the luxury of using their state constitutions to decide that they do not want to follow United States Supreme Court precedent like Atwater and Wren, even Terry. So it really behooves lawyers practicing in state courts to make arguments under their state constitution that we should be charting a different course than the United States Supreme Court has under the Fourth Amendment. The second thing is we need much better data collection. We really need to get our arms around the problem of racial policing. Just yesterday, the Massachusetts Supreme Judicial Court recommended that the Massachusetts legislature mandate data collection around the issue of race and traffic stops. In Maine, Representative Hinkman has proposed similar legislation. It's crucially important that we understand who is being stopped and targeted by police. And then third, this goes back to what I was saying earlier. I often hear judges, former judges, talking about how the need for criminal justice reform will come through policy change, will come through new laws or legislative actions. But I would really encourage courts to be introspective here. It is absolutely true that they are partially responsible for the mess that we are in, and we are not going to get out of it without their help. And so immediately today, and without overruling Wren, judges can decide that they won't play the game anymore of just accepting at face value what police officers declare to be suspicious. And they'll think more carefully, more critically about whether what a person is doing really rises to the level of something that is worthy of law enforcement interaction. And so I think if we focus on those three things, which can be done without much difficulty, I think there's a lot of support for that. That will go a long way towards ending some of the disparate racial outcomes that we see in the name of trying to reduce our dependence or the problem of drug use disorders.
Professor Pulos, I know you run the Washington State Reentry Program. How is that as a solution to the war on drugs?
Sure. So it's actually the governor's statewide reentry council. Somewhat ironically, during law school and now after, I've worked for both the federal government and the state government now, which I didn't expect, but that's how it turned out. And I'll reiterate, I'm not speaking for actually the statewide reentry council or the governor today, because my views probably go a little bit more radical than some folks as far as drug policy goes, and I'm okay with that. So our work largely involves addressing, what happens while people are incarcerated that could either be conducive to successful reentry or compound trauma. And we've found that people's prison and jail experiences often actually compound trauma, and we're making shifts within our prisons and jails to A, focus on diversion whenever possible, but B, change the culture within correctional facilities to be conducive to reentry, and then finally to remove the major barriers, collateral consequences to housing, to employment, to professional licensure, et cetera, that are all detrimental to public safety. And if it's okay, I would love to comment too on your earlier question about where do we go from here.
Yes, please do.
Okay. Great. So a quick story. During law school, I was able to intern at the Office of National Drug Control Policy in the Obama White House, and I made an unlikely friendship. Made a friendship with a classic military haircut, drug enforcement, international interdiction military guy, and who was advising the president on international interdiction efforts, career federal law enforcement officer. And he and I would go to lunch together and talk. And he told me once he was down in a South American country, Colombia or somewhere, and he had this meeting with him and some other senior White House and political officials and stuff from the US, and members of the Colombian delegation were meeting together and discussing international policy. And the guy from the US who was in charge was pointing his finger and saying, if it wasn't for these drugs coming across the border, we wouldn't have any trouble with cocaine. And while the guy was talking from the US, the Colombian representative kept tapping his nose, just like this. And finally, the US representative said, what are you doing? Why are you tapping your nose? And he said, the problem is the greedy noses in your country. Until you can control your greedy noses, there's nothing we can do about the supply. So fix that. And that sums up the endless battle. If we had more time, I'd love to talk about the connection between prohibition and violence and violent cartels. You just don't see, if the Budweiser shipment doesn't come in, the bar owner does not shoot the Budweiser representative. These are things we have to consider. Of course, during alcohol prohibition and Al Capone and all that, it was a much different story. So I wish we had another hour. I'd love to just dive into this stuff. Maybe we could have another session sometime. Where we go from here, to put it really simply, I think we should reinvest a lot of the funding that we're currently using to incarcerate people and invest in vulnerable communities, invest in education, prevention, treatment, and recovery, and shift drug laws substantially so that they are conducive to a public health approach rather than a law enforcement-based approach to addiction.
Excellent. Well, we are sort of running out of time. Mr. Arayave?
Just one last thing I wanted to touch on, and that has to do with marijuana. I was reading a little bit last night about the no-knock warrants, and they're talking about how they increased exponentially from the 80s to current days. And they indicated that the majority of the raids were looking for marijuana. These no-knock warrants are very, very dangerous, not only for the targets, but also for the police. And that was what was going on with the lady that was killed in, where is it? Louisville. But marijuana, I think the government should get out of the marijuana business. They should have gotten out a long time ago. The laws, the marijuana laws, are much, much more harmful to the public than the marijuana itself. I found an opinion by a DEA administrative judge from 1988 One of the things that he says is that marijuana is one of the safest therapeutically active substances known to man. By any measure of rational analysis, marijuana can be safely used within a supervised routine of medical care. So we're spending all this money to catch people smoking marijuana, to put them in jail, ruin their lives. It has all kinds of consequences. These kids, high school kid gets caught with smoking marijuana. It affects the college that he goes to. It affects his job opportunities, his possibility of going into military, all these things, all these negative things. We're going to have to get out of that. We're damaged. We're doing more damage to people than any benefit derived from this law. And also, like Chris Pulos just said, all that money from putting people in jail and that goes into enforcement could be used for treatment of perhaps harder drugs, of people that are addicted to harder drugs. And I hope that in the near future, something like that comes about.
So I think we're going to wrap up here in a moment. We are running out of time. I guess for each panelist, what's one thing you would have some of our attendees focus their attention on as it pertains to the war on drugs? And I guess we can start with Professor Chapman.
Back to my point of charging reform.
Professor Pulos?
I would recommend Googling the history and understanding the true history of drug prohibition, because when I was a kid, I was taught just say no. And then I learned with some experience that wasn't really effective. I learned that the next level of awareness is that kind of the drug war was a great effort, but it failed. And then as I continued to understand the motivations at the highest level, not from law enforcement or drug users or even drug distributors, but from politicians at the highest level, and how that all started and which communities were targeted and all of that. And historically, that really is what made a major shift for me. So study the history. I'd recommend a book called Chasing the Scream by Johan Hari. And just Googling drug prohibition history too will be a great start.
I second the recommendation on Chasing the Scream. It's a very good book. Professor Drake.
So we've largely been talking about the federal side of things, federal drug prosecutions, but relative to state prosecutions, it's a very small percentage. And so what I'm about to say applies both to drug crimes, but really any kind of crime. And that is, we have to make sure that defendants can even begin in a fair way to contest the charges that are brought against them, regardless of what those charges are. We have a crisis in this country right now with the availability of counsel. Many people don't get the lawyers that they need to help guide them through the process. Even when they get lawyers, often those lawyers are part of offices that are not well funded, that are nowhere near equipped with the same resources that the prosecutors and the police departments have. And so we can at least, as a baseline, make sure that anybody who is accused of any kind of crime has an attorney. That attorney has the resources that she needs to fully investigate and litigate that case. And so we don't wind up with the very real fact of innocent people pleading guilty to any case type, any kind of crime.
And Mr. Ariave.
Well, if you have a drug case that involves a substantial quantity of drugs, diversion and those sort of programs are out of the question. But if you have a personal use, simple possession case, I would recommend immediately reaching out to the prosecutor. Like Professor Chapman said, the charging decision is very, very important. And if you can work with the prosecutors, a lot of time you can talk to them and suggest to them that perhaps your client is in need of treatment and not jail. And many times you'll find that they'll go with you and help you out in that. So I think that's something that needs to be explored right up front. And again, if your client is carrying 5 kilos in a suitcase, then that's not going to happen.
Well, on that note, thank you, panelists. Thank you to those who attended. Thank you to Cameron Rivera for helping me put this event together. And thank you to the Multicultural Law Society for sponsoring this event. That concludes our panel. We hope this was informative. We hope that, and we hope to see everybody that attended at more events in the future. So thank you, everyone, and have a great day.
Thank you.
Thank you,
Thanks,
everyone.
Brendan.
Great to see you all.
You too, Chris. Take care.
Take care.